Good afternoon, everyone. If you could have a seat, please, so we can get started. My name is Barbara Marcum. I'm the Director of Senior Resources for the City of Westland. I'd like to welcome all of you. This is a wonderful seminar. It's informational. It's entertaining. They introduce that information in such a great way. So I've had Jim Schuster, who is an elder law attorney, was one of the first elder law attorneys certified in elder law in the state of Michigan. Jean Richards. We have Linda Friedland. Linda Friedland. And she is a probate litigator. Jean is an estate planner. Jim Schuster is an elder law attorney. So between the three of them, they have experiences that they'd like to share with you, the things not to do. So I welcome all of you. I hope you enjoy this presentation. We did hold this about 6 months ago, had a wonderful crowd, and they had just reviews. So I hope you enjoy it and get what you need from the presentation. Thank you.
I'm Jim Schuster, certified elder law attorney. This is my book here, and I hope you get a chance to take a look at it because I'm not going to go all the way through it. We have so much information here that just going through the book, I've done this in an hour program with questions. Let me just suggest that if you want, I call it the Elder Law Mini Course. If you want to really say, what should I know about, let me just say, you might take a look in the book. But I'm not going to talk about that right now. What I want to talk about are some problems that just some people will never hear of unless I say it today, or you run into it in life. Yeah. We're going to talk about some things that everybody needs to know that a lot of times people never find out. Now let me just ask a sort of a trick question, but I think you really know the answer. What is your most valuable possession? What is I'm speaking to you individually, your most valuable asset? Well, we could go through and ask people to raise hands and take guesses, and I'd probably say, nah, it's not right. So we're not going to do that. I'll tell you the answer. It's your good health. Your good health is your most valuable possession. Well, why should I mention this? I'm a lawyer, I'm not a doctor. Because if you don't know your legal rights, especially relating to Medicare, you or your spouse or somebody you love will not get the best health care they need. You know, I know one of the most famous litigating attorneys in the nursing home, assisted living environment. And by the way, I see Regency's building a beautiful complex right up the road. I mean, Jules Olsman is the guy that families have to go to when something bad happens to a family member in, a nursing home, hospital, or assisted living. Jules has a simple saying, and I wish I could mimic him exactly, but I'll try, and it goes something like, Schuster, there's one thing to remember, falls kill. Falls kill. What does that mean? Well, I think we all know, but just to explain a little bit, a fall leads to a person's decline in health, and from one thing to another to another. Well, I think we all know in our experience a lot of people have fallen. Maybe they haven't died. Matter of fact, I don't know anybody directly has. But how about a couple of stories from my experience, and I know you have similar ones, but let me give you a couple. How about June, our neighbor? She's still our neighbor. She's gets around with a wheelchair now. A few years ago, she used to be a beautiful, active gardener, a young woman of 82 at that time. And beautiful garden. Well, she had hip surgery, and it takes a while to recover. And then something happened. I guess her recovery wasn't complete. She had a fall. And then one thing led to another, and she never recovered. As I said to you, she uses a wheelchair now. Her garden is empty and forlorn. How about the guy who used to live across the hall from my mom? This guy, right now I'm embarrassed to say I don't recall his name, but let's say Bob, and he was like this shining TV personality from the, like the 50s or something. I mean, the guy was always beautifully dressed. He was sunshine. He'd walk in, smile, and, say hello to everybody. Well, one day he came back to the apartments from shopping, and he fell and broke his hip getting the bag out of the car. Well, we saw him in rehab, and he was the ladies' entertainment. He was the brightness of the table. Everybody was cheering and laughing. We just knew this guy's going to sail through it, and he's going to come out just as good as ever. Well, Bob didn't. He didn't get all the way through this recovery. He had a fall again. And this time he picked up something, was it pneumonia? And he passed away about 4 months later. I remember the sad last time I saw him in the hall. A friend said to him, "Bob, how you doing?" He said, "Not well, not well." And he stumbled into the room feeling not well. Why do these things happen? I'll tell you why. From my point of view and from what I see, Medicare is not giving people their rightful recovery, what they need. I had my mom in a rehab facility, and I know a lot of you know about how that goes. They get 1 hour a day of rehab and 23 hours of immobility because they're a fall risk. In other words, they get worse. You go to the emergency room and you lay in that bed for 5 days. You go on Friday, they don't see you till Monday. They do lab tests, and you don't get the lab test till Tuesday. You can't get out of bed. You're a fall risk. You know what the answer is? That especially, let's just say we can't change hospitals, but I'll tell you one thing we can change, and that's rehab after surgery. So listen to this. I had a lady in my office, client of course, last week, and she said, my husband fell 3 times since last fall. And, he used to walk with it, but he had his first fall, then there was a third, then a third. I was saying, well, what's going on? She said, well, the rehab. They just get him to the point where he's getting on that walker. They just get him to that point, and they say, oh, we got to take a 4-week break. And he loses all the progress that he had, then he has another fall. Well, we know where that story is going. The gentleman's never going to get better. He's only going to get worse. I said, no. Change the company. There is no requirement in Medicare that you have to take 4 weeks off. None. Change the company. And I gave her the name of a company I respected. And I will see her later this week, and I expect her to give me a much better report. The therapy company was the problem. They're cutting people off therapy too soon. When a person is walking every day and they fall and break a hip, the goal should be that they go back to walking every day, not that they can get up with a walker and shuffle into the kitchen and then hurry back to the couch before the people are being cut off short. So the message here today of all these stories is Medicare will pay for full therapy so that you can fully recover from your fall, your surgery, or whatever. And believe me, that isn't happening. And I just got word earlier this week that CMS, is the federal Medicare agency, administers Medicare. They're going to allow nursing homes to use more group therapy now. And rehab therapy is supposed to be personalized. The therapist is supposed to watch you, watch your gait, watch your balance. What are the problems that are causing a person to have, the problem of walking? Why are they falling? It's not just a matter of, do you know how to use the walker? Do you know how to put one foot in front of the other? They're supposed to personally observe. Well, with group therapy, you know how much observation goes on? None. Let me tell you about another problem I heard just last week related to this one. And I know in this room, I could ask for a sea of hands and probably get 20% of the people heard of this one. Talking about mom, and she went to the hospital, and she got released with order for rehab, but now she's back in the children's home. Why? Well, guess what place had an opening in their rehab bed when, it was time for her to be discharged? Well, here's an easy question. I think everybody knows the answer. What nursing home always has an open bed? Answer, the worst one. So they took her out of there on Friday. They said, we know she just lay there unattended all weekend. We brought her home. She's not done, but she is getting nowhere there. And they then said, Well, you know, and these folks happen to live downriver, so I can tell you the name of the nursing home that they wanted to go to. They said, well, Applewood, you know, down there in Van Horn, or is it Born? Van Born. Anyways, Applewood is a real good facility, but they were full when Mom was getting discharged from the hospital. I said, well, you know, if they have an opening within 30 days after she left this other one, if they had an opening after 30 days, within 30 days after she left this one, she could go right there. She would go right there without a doctor's order, without a return to the hospital. She could just go to Applewood and they'd start her therapy there. How many people know that? So what's the point? Mom or dad or yourself is in a nursing home that's not doing good rehab. You know, you had your hip surgery, and the place where you want to go, it doesn't have an opening. You know, when they have an opening, you can just transfer right over there. You can transfer from skilled rehab nursing home to nursing home. You can go home, and if they have an opening within 30 days, you can go there within 30 days. I mean, I talk with professional social workers, and a lot of them are saying, what? I didn't know that. Anyways, let's see. I want to just cover some other points. And by the way, I think you can tell that this is not your standard, you all need a will program. You'll get that later. By the way, Gene will make sure that Gene will make sure when you leave this program, you're going to know what you need and what not to do, right? I'm just trying to cover some of these rare points that nobody ever talks about. Okay, I always like to raise this one. What are the two most common causes of medical malpractice complaints? The two most common causes. All right, once again, we don't have time to raise hands, take guesses. I was reading, my wife, who was also had about 4 or 5 falls, but we got her through that, thank you. I was in the doctor's office or the surgeon's office reading the Medical Office Economics book, magazine. And in there, the author said, I do review doctors' cases when there's a lawsuit, and you know, I've reviewed these and I've come up with the two most common causes. So from this doctor's report, the two most common causes of malpractice complaints, and that's when something bad goes wrong. You know, like maybe dad's given blood pressure medication, his blood pressure drops to 0, and maybe he dies because of it. You know, they gave him the wrong stuff. Yeah, that's it. That's the number one malpractice cause. Failure to give a person an appropriate medication. Failure to check if a medication is contraindicated with what they're already taking. And you go, what? No doctor's supposed to do that. You think the nurse in the office would make sure that there's no problems with what I'm taking. It's the number one cause of medical malpractice complaints. 2, the second one. This is also equally, you might say, stupid or what? The second most common cause is failure to check on lab results. Failure to check on lab results, believe it or not. So what happens? The doctor orders the patient, to the lab for some tests. Number of things can happen. The patient maybe just doesn't get there, forgets whatever, doesn't happen. 2, gets to the lab, maybe the lab gives the wrong test. So you're here to have your cholesterol checked. Oh, I don't know, I'm doctor here, whatever. Lab does the wrong test. 3, lab does right test, but doctor's office doesn't check on it. There it is. And what happens? Of course, if there's an abnormality, which leads to serious indications that need immediate medical attention, the doctor's never going to find out about it. So this is one case. A message to you is no news is not always good news. All right. What's the moral there in these two stories? Let's just say that you're very sick, or maybe you're in the hospital to have surgery. How can you put these two stories together? And why is a lawyer talking about them? Simple. If you have a patient advocate, a healthcare agent who is authorized to take any action for you right now, and if the patient advocate, your healthcare agent, is active and informed, you won't have any of these problems we're talking about. None of them. You're in there in a crummy rehab center, your patient advocate will say, Mom, Dad, brother, sister, you're out of here. I found, we're going to that one that we tried to get into before, didn't have an opening. They're open and you're moving this afternoon, all right? Well, how does a person become a patient advocate and a healthcare agent? Well, as you probably know, being an elder law attorney, I happen to review a lot of these estate plans. You know, a lot of people go to these lunches where they get sold these trusts. They get these big fat binders, and they're supposed to fix everything. I have a trust. I thought it took care of everything. So when we, get into it, we find the healthcare power of attorney or the designation of patient advocate. And yes, you folks who have these big fat binders at home, go and take a look. You'll probably see you have a designation of patient advocate, which is good when you're dying. No good at all if you're having trouble with rehab or they're trying to, quit on the job. No. Your healthcare agent under those documents has to say, well, Dad, when you're dying, I'll be able to help, and until then, you're on your own, okay? I mean, no good whatsoever. No good. And by the way, it's not good enough to say, well, my daughter always goes with me to the doctor's office. We haven't had a problem. I'm talking about times when there are problems. And when your daughter or your son or whomever needs to, as we sometimes say, get in their face and fix it, they need the authority, okay? So anyways, and Gene will talk more about this because I know Gene and Linda talk about the complete estate planning, avoiding problems, but make sure you take care of yourself. But my message there is everybody needs to have, and that's me included, my wife too, everybody needs to have a complete, immediately effective, right now, healthcare power of attorney. So if you happen to be in the emergency room tonight at 10 o'clock, your healthcare agent is authorized to do anything that needs to be done without any two doctors' letters. No, you don't have to be dying, okay? Hope we're clear on that. All right. What's another problem that I see, by the way, and, as an elder law attorney, I think you could tell by the name. I deal with elders in times of, long-term care illness and all those issues, when you need, a lawyer around to say, what's my Medicare benefit? Are they trying to screw me out of what I should be getting? The answer oftentimes is, yeah, they are. They're trying to save money, but that's a story for another day. Another problem we see when, let's say, a daughter or son or, tries to help out, or sometimes when the wife tries to take care of business of the husband, they have a durable power of attorney that is not complete. I used to see, and I think the lawyers have improved their game, but I used to see a lot of powers of attorney that did not allow access to a retirement plan. And what that strictly meant, if Mr. Smith, is very sick and they got to do some home modification and Mrs. Smith wanted to access his IRA, she couldn't. Because with a power of attorney that does not have a retirement plan provision in it, even a wife cannot do anything on a 401k or IRA retirement plan because those are individual properties, individual assets, okay? But when it comes to children, it's worse. How about I reviewed many powers of attorney, durable powers of attorney, and when it comes to credit cards, and you know how there might be a scam, sometimes, mom might call her daughter and say, there's some funny charges on my credit card, and maybe mom's a little hard of hearing on the phone like my mother was, and she doesn't want to call the call center, so she wants her daughter to do it. And I review these healthcare powers, durable powers of attorney, and they would only say, as far as credit cards, my agent can use my credit card. It didn't say anything about contesting charges. It didn't say anything about tearing up the card and throwing it away, terminating the agreement. It just said, can use my credit card. And so once again, folks have the big fat binder. Take a look at your credit card clause. And back here, Don Roffey, my paralegal assistant, who will be helping with the drawing, don't forget the drawing, often says, look, these powers of attorney don't even authorize a son or daughter open up a new bank account. A lot of times, really understand, you could see the scenario, Mr. Smith has died, maybe Mrs. Smith has Alzheimer's or something, so, she moves closer to daughter, and daughter wants to open up a new bank account over here, instead of where mom lived, in the country. And if the power of attorney doesn't authorize opening up accounts, the bank or credit union won't do it. Once again, we're presuming that mom is, kind of advanced in her disease and daughters take care of everything. So anyways, a complete durable power of attorney is almost rare and is absolutely necessary, all right? Okay. Oh, yes. Now, there's a question here for the cable. We got a special routine cable. Do we have a wireless mic?
We'll do that later.
We'll do that later. Ask your question. I need to repeat it for the cable, folks. Go ahead, please. Who has a question? Go ahead, please.
My husband had a 401k, he died, I was able to cash it out, just by sending in his death certificate, and I'm his wife.
Yeah. Now, what you just said, you pointed out that when your husband died, he had a 401k, and as his wife, you could just cash it out. You know when that wouldn't be true? Almost never. What if, because 401ks require distributions to spouses upon death. What if he had an IRA and he named a child as the beneficiary of one IRA? You know, maybe there's a big one and a small one. And so that, let's say that child has died, you know, tragedy happens. As a wife, you wouldn't have been able to access that IRA. All right, but really, get back to my earlier point. I wasn't talking about when somebody dies. I'm talking about during lifetime, when we need to spend money, maybe to make some home modifications, the bathroom or the whatever. Can the spouse get money out of the 401k IRA? No, without a power of attorney authority. So thank you for your point. As you clarified, on death, there's usually no problems. But I think the goal of my talk is to say how to protect your health and stay alive your rightful amount of time without dying prematurely. Okay, let's give you, now here's a couple nuggets, and these things are, once again, I often hear from social workers saying, I didn't know that. So let's say that you are dealing with long-term care, and we're talking about husband and wife. Now, we're not talking parent and child, talking, let's say, Mr. and Mrs. Smith, dealing with long-term care issues. Let's say that Mr. and Mrs. Smith have a nice house here in Westland, a nice house worth about $100,000, and they have $80,000 in the bank. Well, why are we saying that? Well, I'm sorry to tell you that Mrs. Smith has Alzheimer's, and it looks like Mr. Smith can't take care of her anymore, and she needs to go to a nursing home. So she, went from the hospital to the nursing home, and it's going to be long-term care. She's not coming back, Alzheimer's. And so they tell him, you're going to have to spend half your life savings. You're going to have to spend half of that $80,000 before Medicaid will pick up and pay for her long-term care. And he might say, $80,000, that's hardly enough as is. But I got to spend $40,000 of that? Isn't there something I could do? And the answer might be, well, the answer is if you see an attorney, like an elder law attorney knows the ropes, there are things we can do. But here's a little tip in advance. Suppose that couple knew that a nursing home was in the future, okay, for one of them, long-term care. Believe it or not, they could have put their house in a revocable living trust. Simple revocable living trust. We're not talking thousands of dollars. Simple revocable living trust. And when Mrs. Smith went to the nursing home, Mr. Smith, this is legal, so I got to give you the legal twist, could go to his elder law attorney and say, Mrs. Smith is in the nursing home. The elder law attorney would say, fine, we're going to take the house out of the trust and put it in your name. What would that do? That would save him $40,000. And just for those who are sort of engineers in the room, people like, to see the data, it goes like this. Medicaid says a house in trust is like money in the bank. It's not protected, it's not excluded. A house in trust, you can't get Medicaid if you have a house in trust. You gotta either sell the house or get the house out of the trust. When you get the house out of the trust, it's the same as spending it under the Medicaid weird rules. So Mr. Smith takes a $100,000 house out of the trust, and what happens? Well, with the house in the trust, it's like money in the bank, $100,000 house, $80,000 in the bank. He has to spend half. $100,000 house, $80,000 in the bank, $180,000 he has to spend down to $90,000. How does he spend that down? Taking the house out of the trust under the Medicaid rules, the same as spending it down. Weird, but true. So the moral there is, a couple could save $100,000 just by having their house in the trust, then taking the house out of the trust. Now, don't do that at home. You'd want to consult with an elder law attorney just to make sure that it applies. But my point is, a revocable living trust can be a hidden savings device. But you got to be looking at long-term care. Okay. Point two. Let's say that once again, Mr. Smith, same couple, has a heart condition now, and he's concerned that he's going to die first, and Mrs. is going to be in the nursing home, and all their savings, because he saved the $80,000, all their money they saved is going to now go to the nursing home, and it would if she inherits it. But he wants to protect her, so he doesn't want to give the money away. He still wants to protect his wife. What can he do? We can do a will, under the Medicaid law, we can do a will that provides in there that the money goes to the wife. They can sell the house. They can take the $80,000. There can be $180,000 in a supplemental. It's called a testamentary. Means it's formed with the last will and testament. It's not living trust. It's a post-death trust. A testamentary trust, $180,000 in it for the supplemental, the extra needs of his wife in that nursing home. And Medicaid cannot and will not make that $180,000 spent on the nursing home. It'll all be used to make his wife's life better. Okay? Very, very few people know about that, but once again, if my spouse has a long-term care condition and I'm concerned they might die first and I'm managing all the money, I have a will with what we call a supplemental needs trust. It says that all the money in there will only go for her extras. If she's in a nursing home, if she's at home, it'll take care of her. But Medicaid will not require that money to be spent. Okay? Now, by the way, the will, this process is, property must go through probate, so it must be set up because a joint account doesn't do the same thing. It has to go through probate and be sent to the testamentary trust. Yes, sir, I think you had a question.
Yes, I did, sir. Does that also protect cash and stocks?
Yes. The testamentary trust, you can pass any property into that trust as long as that property goes through the probate process.
So, in other words, if you do, let's assume you have wealth, you put all that in this trust, and it would be safe?
Yes, remember, it is a spousal trust, yeah. Yes, it'd be, yes. All right, now, just because I'm supposed to repeat the question, and I'll also say that, by the way, Gene Richards may touch on this subject because it's so important, and maybe you could use the living trust to fund the testamentary trust, right? Linda's our probate expert. She brought her boxing gloves, Gene. We're having fun. I'm sorry. Okay, the question was that the gentleman asked over here. He said, well, this testamentary trust thing, can it be used for stocks and bonds and investments? Answer is yes. Yes, it can.
That would protect them. Say I got sick and went to a nursing home and wasn't coming back, but it was protected. Our assets, and my wife would.
Now you ask, what if you got sick and went to a nursing home? Would it protect your assets? No. Remember, the qualifying condition is somebody must die, a spouse. It only applies to spouses. One spouse must die. Yeah, then this trust sets it up for the surviving spouse. Wait, we're not taking volunteers to die just yet. But okay, I'm going to be wrapping up in just a few minutes. Turn it over to Gene and Linda, who will really give you the whole buffet of information. What I tried to do is give you some very pointed tips. Now, I grant you, some of these only apply to a very small audience, like the will with the testamentary trust. I mean, yeah, in my office, we do it for everybody. But clearly, you could see it works only when we're talking about long-term care for a spouse, husband, or wife. But I think the medical tips are something that not only do you need to know about, but you need to know more about them, because Medicare, the cost containment, in my view, is only getting tighter and tighter, and that means people will be getting less and less of what they need. Okay, just any quick question, anything I really got muddy and somebody says, you gotta have it clarified? Hey, good, no. Then in that case, let's go to some real fun, some really good stuff. And if I might put on my wrestler imitation announcer voice. And now stepping up to the platform is an excellent elder law attorney and the excellent probate litigator. I give to you Gene Richards and Linda Friedland.
Wow, Jim, what did you have for lunch?
Those are good cookies.
Good cookies in the back. Good afternoon, everybody. My name is Gene Richards. I am a fellow elder law attorney, estate planning attorney, here with my colleague Linda Friedland. She actually does talk. Jim keeps pointing at me. You speak, don't you?
I do speak, yes.
All right. We're going to do a couple of housekeeping things real quickly. First of all, for the cable folks, how close do we need to be to the mic? Can we stand like this? We're good?
Are we
All
both
right.
on?
And are we within the scope of the okay? Linda and I tend to wander around, and so we just want to make sure we're doing this correctly. So a couple of things. First of all, in your folder, we're going to be using the piece of paper that's on the left side and 4N. So 4 pieces of paper inside has a document that says Why Families Feud. So I want you to take a second to find it. Use this moment to stretch if you need to. So stand up, stretch your legs. All right, you've had an opportunity to stretch. Hopefully everyone found the handout we're talking from. Why Families Feud. Does anybody not have it? You do not have it, sir? Okay, we're going to make sure the lady in the red jacket's going to bring you one. Hold your hand up. Yes, sir. Anybody else? All right, we are good to go. So let me tell you why Linda and I are here together. It's not that we're insecure and neither one of us can talk for ourselves. It's that we come at this from 2 different perspectives. Linda and I work at the same law firm. That's Cummings, McClory, Davis, and Acho. We prefer to say CMDA, located up at 6 Mile and Haggerty on the Schoolcraft campus area. Linda is a fabuloso probate litigator. That means when you need an advocate in court to argue your case and win, you want to talk to Linda. I'm the guy that does more of the elder law work, the planning, the trusts, the Medicaid, the VA benefits. So the goal this afternoon is to talk about proper planning. Everything that Jim said is kind of summed up on the back of this sheet. For instance, number 1, and this is our little theme today, what is good planning? Good planning is designating the right person with the right power at the right time. If any of those 3 are out of whack, there could be complications and problems. You go down to number 5. You need to have a powerful power of attorney, both financial and medical. Jim was speaking to this earlier. We're going to give you more information on that. You want to include planning for Medicaid, the high cost of long-term care, veterans benefits for veterans and their spouses. And number 8, you want to keep those legal documents up to date. They need to be about this time in your life, not where you were 30, 40 years ago. So Linda and I come at this, we're going to take each of these points, and I'm going to talk a little from the planning, and she'll have stories about what happens if you don't do it right. So you're going to learn how to do it, and you're going to learn what happens when you don't do it correct. All right.
Yes.
So our title is Why Families Feud in Probate Court and How to Prevent the Mayhem. How many people think there's bad air in probate court, and when people go through the door, they just start fighting? Actually, some people believe that. Actually, the probate court plays a very important role, and Linda and I are going to share talking about this. So first of all, we want you to understand, why do we have probate court to begin with? Probate court is there for 2 main reasons. For events that happen during life, and for handling a person's affairs after they pass away. Now, what do we mean about during life? The probate court is there to protect people who can't protect themselves. If they're incapacitated, maybe they're a vulnerable older adult, maybe it's a person with disabilities, but they need to be protected. The probate court, we're in Wayne County, so our probate judges in Wayne County are the ones who have the authority to step in, put somebody in charge, and to watch over that person's affairs. Only a judge can appoint a guardian to make care decisions or a conservator to manage money. Now, you just said, some of you, we don't really want to be in probate court. We'd like to avoid that. And one of the ways you're going to avoid that is by having a power of attorney, whether it's for medical or financial. The purpose behind those documents is to name the right person that's going to have the right power to handle the situation. Jim mentioned a 401k, and the point is you have a married couple, they may have a lot of money stashed and saved in their retirement. It could be an IRA, it doesn't have to be a 401k. And one spouse gets sick. And in older couples, oftentimes the man earned, they're still in that generation where the men often earn the money. And so they may have a lot stashed away, and so suddenly he's had a stroke, he can't communicate, he can't manage his own affairs, and his wife is trying to get to that money. Unless she has a document, a power of attorney that says she's allowed to go in, make investment decisions, make beneficiary changes, withdraw assets, she has no authority over that account just because she was married to him. And now Linda's going to talk about what happens if that piece of paper, if there's a problem with it.
Now, the operative word in the term power of attorney is power. This is a very powerful document. Even the most poorly drafted powers of attorney provide a lot of power under the Michigan statutes. So if you choose the wrong person, or as Jean said, even at the wrong time, havoc can be wrought on your life. This power of attorney has the right to move assets, sell real estate. I've handled cases where children have said, hey mom, build an extension, sell your home, put an extension on our home, and we'll take care of you. Well, and it worked out just fine. For Medicaid planning purposes, she basically bankrupted herself, moved in with her daughter. They threw her out. She was homeless. Fortunately, she had 2 other responsible children who paid to hire me, and we had depositions, a lot of tears, a lot of crying, going to court, expensive litigation. Basically, I alleged fraud. It's not usually your child who throws you under the bus. It's the spouse or the boyfriend. Hey, we can rent out this space. This was a great suite. She had her own kitchen, her own room, her own living area. They threw her out and rented it. So we got all that back. They had a choice between either getting a home equity loan and giving her all of her money back or selling the house. And I had a court order to do that. So the wrong person can really cause havoc. Too many people choose the oldest child or the child who's around. Let's say you have 5 kids, they're all up, they've flown the coop, they're successful, they're college educated, and there's one who's home with you, just never got married, never got a college degree, or maybe did get a college degree, but in between jobs, otherwise known as unemployed. You have a question? Okay. And they're home. And the idea, sometimes this child will rationalize his behavior by saying, well, I'm here to take care of mom in her old age. Mom will choose that child to be the power of attorney because he's there. Okay, this child doesn't have his own money. Little by little, mom's money is becoming his own money, and you can see what happens. Suddenly he's using that power of attorney to become the beneficiary of all of her life insurance contracts, her 401k, her Roth IRA, her bank account, her brokerage account, her certificates of deposit. Well, what would the probate court do in such a situation? Nothing. The probate court isn't monitoring this situation. They won't know what's happening unless somebody files a petition to undo everything. Now, what happens upon mom's death, if nobody intervenes, will be upon her death, everything goes to that one child outside of probate. And then it's up to the lawyers, once hired, to undo everything, prove that mom had entrusted the wrong person. These are hard to undo. These are very hard to undo. There you go.
So the lesson to take away is you need powers of attorney. They need to be appropriate. It's important to have the right person. And if things go sideways, the probate court is there to protect. So again, it plays a role during life, sometimes even when powers of attorney are misused. Typically, we think of probate court coming into play when someone has passed on and we need to probate their will. How many of you, well, I won't ask the question because I don't want you to embarrass yourself. Many people think that with a will, they go around or skip probate court. That is not the case. If a person has a will, that will is only usable if you march down to the court and you file it with the probate register. You probate the will. So don't think you're missing probate with a will. There's other tools to do that. The probate court after death is going to handle the wills that come before it. They're also going to take care of assets that don't have a named beneficiary or there's not a surviving joint owner. The court is also going to step in if there's a fight. And these are the ones that always get attention. But if the children or the beneficiaries disagree about the will, or maybe it's a trust, or they think someone's taken money while the parent was alive, the court can address those. So the probate court plays an important role, is our point. But you want to stay out of there if at all possible. You know, Linda makes a lot of money over people who've just tripped up, messed up, didn't do their planning correctly, and wind up in probate court. Is that right, Linda?
Or sometimes the planning was done perfectly. They've done everything right, and life changes. I had a client who obtained a power of attorney, a well-drafted power of attorney by Mr. Jim Schuster, and a medical power of attorney. But mom appeared competent. She sounded perfectly normal when you spoke to her, but she was giving all of her money away to various strangers. And so this client came to me and said, no, what do I do? I've done everything right. How do I? A power of attorney allows you to speak, step into the shoes of your loved one, but you can't kick them out of their own shoes. So the only way to take over is to get those two doctors' reports to prove that she's incompetent. Or in this case, we ended up having to obtain a guardianship. And mom signed that petition. Okay, my bad, I shouldn't be giving away all of my money. It was a very simple situation. It's not always simple. Sometimes mom will fight you. I'm not going to let you be my guardian because you're going to put me in a home. I don't want that. I want to fight you. Then that takes time. You may hear something called the probate code. There is no probate code in Michigan. It's otherwise known as EPIC. That's the Estates and Protected Individuals Code because it protects individuals who need protection and estates. So when you file a petition in probate court, you have to designate, is this a decedent's estate or is this a protected individual's estate? And there's other legal terms that go with it, but that's the gist. So,
okay.
There.
All right, so now let's get into the nitty-gritty. If you're on the first page of our outline, we're down into B. What are some of the common igniters of these feuds, or think of it as what are some common mistakes? First of all, people don't do anything. If they do absolutely no planning, what happens? Well, first of all, there are some rules in place that give guidance on how things are going to play out. Unfortunately, frequently, it's not what they wanted. An example would be if Linda and I were brother and sister and our mom was incapacitated and we needed to go to court and one of us needed to be in charge. It doesn't matter that mom loved me most and that I was the best and the favorite. The fact is, Linda and I have equal priority and we're going to get in a fight, possibly, over who...
She's going to steal all the money.
Because I'm going to steal all the money. The favorite son, I'm supposed to get it all. We're going to fight over who should be in charge. The default rules say that we're equal in priority. Had mom signed a document, whether it was a power of attorney or a will or a trust that said, in fact, Jean is the favorite and should be in charge, that's not going to happen. It won't happen automatically. So the default rules sometimes don't achieve what people want if you do nothing, all right? That one seems pretty straightforward. The other mistake people make is they plan for passing away, not for events during life. Our phones will often ring and people say, hey, I need a will. That immediately communicates, they're thinking about, when I'm gone, here's what you do with my stuff. Here's who's in charge, here's where it goes. They're not thinking about, what if I'm in the middle of those crazy drivers on 696 or 275, I'm in an accident and I'm incapacitated? What if I've had a stroke? What if I'm out playing golf with my buddies and the golf ball hits me between the eyes and I'm in a coma for a while? They don't plan for those events. So one of the mistakes people make is that they plan for dying and not for events during life. Linda, what are the things that we need to handle life events? What documents? And what happens if we don't have those?
Life documents?
Yes.
Are you referring to the power of attorney?
I am, yes.
Okay, back to the power of attorney again. Power of attorney allows someone to speak up for you when you cannot. Keep in mind, with today's technology, you're more likely to be incapacitated than die. Especially with hospitals today, they will employ heroic methods, employ all kinds of things to keep you alive, from paddles to all kinds of technology that I'm even unfamiliar with. You need somebody to advocate on your behalf.
And if they don't have those, what happens?
The court will decide.
Okay,
The
so they
court will
wind up going to
decide.
probate court.
They end up in probate court. But sometimes probate court is the most appropriate. I've had to rescue clients. The son with the power of attorney, again, this person chose the wrong son. Son wanted to preserve the estate for himself. So he put mother, bankrupted mom, moved all the assets into his name, okay? So she has nothing and she qualified for Medicaid. Now she's in a Medicaid facility. And she's sharing a room with 5 people, and it smells in there, and it's terrible. She hated it. This person called me with a credit card and hired me, and we were able to help her escape. So, yes, you have to do that. The other document is a medical power of attorney, and Jim Schuster did touch on this. This person will allow your chosen person, hopefully you've chosen the correct person, to make medical decisions on your behalf. One thing that Jim Schuster has coached me on is don't just plan for incapacity. Let's say mom's a little nervous about talking to the doctor. Your daughter is a nurse and you want this person to come with you to the doctor, or call the doctor, make inquiries. Or mom's can't drive anymore, needs somebody to pick up her prescriptions and doesn't trust those mail order. A properly drafted medical power of attorney will allow your chosen advocate to do that for you.
Okay. All right. One of the other mistakes that people make is they decide to do it themselves, and this comes up again later, but they rely on joint ownership and they rely on beneficiary designations. They say, I think those lawyers are expensive, they're a pain to work with, I don't like lawyers, whatever the reason is. I went to this seminar and I heard that if I have a joint owner on my accounts or I name beneficiaries, it's not going to go to probate court, it's just going to go to those people. And so they decide to start adding kids to the house, to the land up north, the cottage. They start putting their names on banks and CDs. They name them as beneficiaries. Now, beneficiaries and joint ownership have a place in the planning. The problem is people use them the wrong way, or they don't realize that it doesn't anticipate everything. One of the problems, especially with joint ownership, is you lose control. My favorite story so far has been an elderly gentleman had his boys on their childhood home. It was sort of one of those older, built in the late 1800s homes. And he decided it was time for him. He wanted to go into a condo. He was tired of the maintenance and the upkeep, and he was going to sell his house. However, one of the boys decided he didn't want Dad to sell the house and refused to sign off. Dad's call to us was, well, I gave it to him, I'll take it back. Unfortunately, that's not the way the law works. and he was locked into his house, could not sell it, because he had given his son a joint interest in the property. So while it might have been good for some reasons, it actually came back to hurt him. Joint ownership with anyone other than a spouse is frequently a bad idea. It causes tax problems, it causes loss of control, it in fact can open up that, especially bank accounts and investment accounts, open it up to that person's problems. Imagine a lady's surprise. She had one boy, he was a good boy, she put him on her account of $500,000. The problem is he got arrested for some cocaine in his car, wound up going to Jackson, and the state of Michigan was happy to take her money to help pay his way because he was joint on the account with her. So joint ownership, be very cautious with that. You want to talk to a professional about is it appropriate and how should it be done. I'll let Linda talk a little bit about beneficiary designations, and in particular, well, we can get to that in a little bit too, but what can go wrong with a beneficiary designation?
Okay. Well, Jean touched on a lot of that. When you put a child on your mortgage or on your deed to your home, you're opening up your mortgage or your whole home to that child's creditors. The event that Jean had described is called a civil forfeiture. If you get busted for drugs, the cops take your car. They just take it. There's no judicial order or proceeding ordering that. Your car's gone, your money's gone. That helps fund additional drug enforcement efforts by the police department. And you see that in every city. But just as easily, your child runs into a small child with his car and gets sued. Now that account can be seized. That's very dangerous. The only times I've seen joint ownership work with a child, and I'm going to preface this by saying please don't do this, where you have an elderly woman, elderly father living with one child, and they have an only child, no other children, and that child is in fact taking care of them. Child is living in the house, and that child is the only heir. There's no, oh, I want to give my money to this charity or to this. No, all my money is going to that child. That can work when you push aside the other events that we just discussed. But still, there's some issues with that. From refinancing, when that child inherits the house, that child isn't going to get the step up in basis. So if mom bought this house in 1920, puts her child on the deed, that child is only going to enjoy 1/2 of the step up in basis. And that could yield a very large capital gain depending on the value of the home. So don't do that. I did have a case, again, I have to present all my horror stories. 6 children, this was a multi-million-dollar estate. Dad had planned perfectly with his 6 children, owned several commercial properties throughout southeastern Michigan. Very well immigrant family, but very wealthy family. Again, it was the child who was living at home, who ingratiated himself to mom. Never held a real job, never made his own money, but he was there for mom. Now, mom didn't speak English very well, and she's reading through these documents after dad died. The patriarch of the family was gone, and son approaches mom and says, "Do you understand all this complicated lawyer talk?" No. She didn't understand what these trusts meant. She didn't talk to a lawyer because that wasn't her place. Husband went to the lawyer and did all the talking. She didn't understand how this estate plan worked at all. Everything was safely in the family's trust. Everything would have been handled, managed, administered, and eventually distributed through the trust outside of probate. No, mom. Sign these documents called deeds. Put everything in my name. These are large land holding companies. And this litigation took 12 years in Oakland County. We eventually got a lot of that money back. A receiver was appointed. Receivers are expensive. They're with the very large law firms, and they charge between $350 and $400 an hour. If you can avoid having a receiver appointed, please do so. Don't do that. And we had to keep tattling to the receiver. He's going around our backs and selling property. He's collecting rents to which he's not entitled. It was a constant cluster mess. So please don't do that. There we go.
One thing we don't want to confuse you. So you're going to hear things from the planning side, remember? And then you'll hear Linda say, yeah, but.
Well,
Even if you do it
let me
all
touch on that
perfectly, it
real
might
quick.
mess up. Oh, sure.
Yeah, real quick. Gene is the smart one of the group, as you've probably picked up on that. He plans well, he considers every possible scenario. I did divorce for many years. I represent creditors in bankruptcy court, and I do commercial litigation in addition to probate litigation. So I'm naturally a very paranoid individual. So when somebody says, hey, Linda, here, sign this power of attorney, I say, you need power, go to court and get an order. So, and that could hurt me someday. So that, you just, as Gene says, you have to have the right power with the right person at the right time. So that gets the dynamic between the two of us.
Right, the point is there is protection, okay? What Linda's getting at is, if something goes sideways with the good planning that was done, there is a way to address it, is what I take from that.
You can fix it.
You can fix it, you just may need to take action. Okay, moving on. We're going to speed up. Is Barb still... Barb, I'm not sure what our cutoff time is. When they start walking out the door, we know time's up. Okay, got it, all right. The do-it-yourself estate plan. One of my favorites.
Oh.
I really like do-it-yourself estate plans. Just make sure you put our business card somewhere in there, okay? Because invariably, people mess it up. I did a nice trust plan for a Chrysler executive. A few years later, he wanted to change something. He didn't want to pay me to redo anything, so he sent me, hey, Gene, put this in your file. I amended my trust. This is a smart guy. But not as smart as he thought he was. Unfortunately, he was smart in the stuff he knew about. He wasn't very smart in the stuff I knew about, or legal things that we had handled for him. So I had to call him up and say, by the way, you're trying to be nice to the client, right? And I'd say, you idiot, why didn't you just call me? It would have taken less time than the call we're having. But messed it up. People don't get things witnessed. They lose the documents. It's confusing. Lady takes a very straightforward fill-in-the-blank will. If you want to walk away with a freebie today, Michigan has a fill-in-the-blank will called a statutory will. If you're going to do this yourself, please don't do it in your own handwriting. Go find the Michigan statutory will, which you can find online. Just be careful with it. It's a very simple will. It's not designed for Medicaid planning. It's not designed for really, if you want to support charities or you have problems with children. There's no testamentary trust, none of that fancy stuff. This lady managed to mess up a fill-in-the-blank will. She started crossing off things that are supposed to be there and then writing things in the margins. By the time she got done, we had no idea exactly what was supposed to happen. So we wound up going to probate court to try to get it interpreted, because guess what? The kids looked at it from different angles. Well, that means I get the car. No, that means I get the car. And we didn't know who was supposed to get the car because they both were listed with the car in this document. So we went to probate court. Guess who makes a living going to probate court? So they wound up, it didn't save any money or time or frustration for this individual to do it themselves. I'm sure, Linda, you run into a lot of do-it-yourself horror stories. Maybe
Sure.
you could share a couple of those.
Okay, sure. I just got done writing a check for a handwriting expert. Just to hire one, it's about $2,500. That's just to get that handwriting expert in the door. Because invariably, when people are doing these do-it-yourself wills without talking to a trusted advisor or an attorney who can help them walk through the possible scenarios, they're just mad at a child at one time. And that person's disinherited. He's crossed off, then he's added back. Then he's crossed off, then he's added back. Was that her handwriting, or was that sister disinheriting him? So you have to, was that really his handwriting? Oh my goodness. A typical will is relatively inexpensive. Fixing it afterward, when it's contested, is very expensive. Another item that Gene has on his list is improper witnesses. Okay, sister's changing everything, disinheriting the evil brother, and she's witnessing that will. Thank God she had improper witnesses. You can't have beneficiaries who are named in the will or heirs at law serve as witnesses. So In the case I'm thinking of, the will got thrown out because the witnesses were improper. I always recommend a notary public, because at least you have somebody who's neutral attesting that this was signed by the testator on that day. Michigan law does not require notary publics. You do for deeds, but not necessarily a will. Always use a notary. Something I'm running into, and it's very difficult. You used to be able to walk into any bank and find a notary. Hey, I did my will. Do you have an account here? And sometimes even when you have an account, there's no notary there. You have to have an appointment. So it's just, banks are looking at reducing costs. So there's not always a notary. The branch manager's not going to do it for you. I'm a notary. Most lawyers have notaries on staff. It actually saves you time and money to actually walk into the law firm and get it done, and to get it done correctly. Another do-it-yourselfer. The unknown estate plan. I'm doing this will, and I don't want anybody to change it, so I'm going to hide it. Or everybody would know that I keep my important documents in this drawer. Well, the kids have flown the coop. They've graduated from college. They haven't wandered throughout the house in mom's personal effects for years. They don't know where her special drawer is, and they can't find that will. So then we're in something called intestacy, and that's where the probate court will just distribute the assets pursuant to Michigan statute. Okay, now you have a loved one whom you never adopted, but you think of this person who's taken care of you as your daughter or your son. They're going to be left out because they're not an heir at law. So Michigan will determine who gets your money. And that's it.
Yep. So I don't know about you, but I think we're having more fun than the people next door who are watching the Tiger game. Yeah? Okay. Just kidding. Please, see, those young ladies just got up to go watch the Tiger game. Thank you. Thank you to the Madonna nursing students. I know they're here frequently. Thanks for sitting in. Another question. There is a question. Yes, ma'am?
Making out a will and want to make changes, can't you do a codicil?
So the question was, if you've made out a will and you want to make changes, can't you do a codicil? You want to take that one?
Sure. Okay, a codicil is like an amendment to a will. Keep in mind that a codicil has to be executed the same way that the will was executed. So as I recommend, and as Jean recommends, 2 witnesses, non-interested parties, and a notary. The codicil must also be done. 2 witnesses who are non-interested or disinterested, and a notary public. It could be a paragraph. Sometimes it's easier just to go ahead and redraft the will. You know, if you're making a lot of changes. Yeah. And there's also another issue with codicils is who can find the codicil. I execute wills in triplicate just because I give my clients 2 wills. They have one for their binder, one for their safe deposit box, and I keep one in case the evil brother rips their will up. And they can always, Linda's got a will. I've got to be the hero so many times. I do that. And I give you a choice. If you don't want to have me keep an original for you, you don't have to. But if you do a codicil, you have to make sure then if you've executed your will in triplicate, the codicil has to be. And then you have to keep the codicil with the will. So if you've got the will that disinherits Johnny, and then you've done a codicil saying, we've made up, he's back in the will, but nobody can find the codicil, it's not with the will, now you have a fight. But I talked to Mom, I know she was letting me back in. Now you have testimony, now you have a trial, maybe you have a jury, and that's expensive. So you're better off, even with a codicil, coming into the lawyer's office and making sure it's done correctly.
I see how it is. If I'm the smart one, she's the hero. I see how this goes. Okay. I know this gentleman back here behind has a question.
What is Michigan inheritance law?
Oh.
What is Michigan's inheritance law? Or are you talking about the tax?
That's a great question.
You have husband.
Oh, what's the inheritance law? How does it go?
Inheritance law, is it the same in every state?
No.
It's not.
It's never the same in every state. We can answer that question. So I think what the question relates to is, what are the default rules? How do things go when somebody dies without a will? That's called the law of intestacy. And there's a formula that tells us, you know, it starts looking down the family tree. Is there a spouse or their children? Were those children from a prior marriage? So it's a really complicated thing. There's numbers attached to it. So I can't really answer your question directly, but Michigan does have a law of intestacy that applies. Now, I'd like to make something clear. We're not really talking about, at this point, we're talking more about mistakes than actual planning. One thing to tuck away, and maybe it's in Jim's materials or in our materials and handouts. Linda and I aren't smart enough for a book. Jim has a book. He's an author. We just put papers and things in our binder. That's a joke, by the way. But we want you to realize that wills don't handle everything. So when you go to meet with a professional for planning, these are just tools. A will is one of the tools that's used. You'll notice a will is different from a power of attorney, and then there's financial and medical powers of attorney, and then there's testamentary trust and revocable trust and irrevocable trust. All of these play a role. So just because a person has a will doesn't mean it applies to everything they have. That's a key. We don't have time to go down that trail. It's just one of the tools that handles some things. You need to understand how it works and what it does. Sir?
Yes, question. Mr. Schuster touched on this. We have multiple 401s with the matter. My concern is that Mr. Schuster mentioned, I want to protect that where it's not paid down if I had to go on Medicaid. How can I protect that?
So the sort of a detailed question, but Mr. Schuster touched on this was the comment, which so we may have to get the expert on this back up here. But the point was husband and wife have 401ks or retirement accounts. They don't want to lose all of that if Medicaid is required. How do we save some of that? Wow. There are several ways to do that. It depends on all these different factors. Where are we in life now? What do we see coming down the road? What is our time horizon? What if it's a crisis and somebody's in the nursing home today? There's certain things we can do. What if we have, as far as we know, many years? That opens up a whole different set of strategies. But there's no way to answer that question specifically. That's an entire seminar in itself about planning for Medicaid benefits. I'll answer it this way, and then Jim, you can step in or later if you need to.
I'll glad to, just in case.
Of course, Jim will be glad to. But I'll just say there's many planning opportunities. What I run into is people think it's just off the cliff, sort of that there's no options, there's nothing that can be done. I'm not sure I've ever run into a situation where there wasn't some planning, some means to save some of the money that otherwise would be lost. That's just a broad perspective. Now, for the professional to speak.
That's an understatement. But anyways, part of the answer to the question is whose IRA or 401k it is. The IRA or the 401k of the at-home spouse is almost never a problem. By the way, I'm going to give you an answer because you asked the question. So look out. If you convert that into a single premium immediate annuity, none of the money goes to the nursing home because it's the at-home spouse's income, and the income of the at-home spouse is never considered by Medicaid. If it's the spouse in the nursing home, now you've got problems because it's all untaxed money, and it's got to be distributed somehow, some way. One way, sure, you could do the annuity for the spouse in home, but then you got to hire Linda to go to probate court or Jean to go to probate court, Jean to draft the petition and say, Judge, could you please award that IRA or 401k of the nursing home spouse to the at-home spouse so the at-home spouse have enough future financial security? And if you think that's a clear answer, then I'm going to hire you right now because this stuff is, and final answer is, if anybody here can tell me what the Medicaid rules will be next week, you're hired. How about next year? I mean, no, really, it's a government program. Every time they sit down up there, we don't know if they're going to make changes. All we can say is it does change, and it's very difficult to be on top of everything. And when I'm saying it does change, like we just got a notice at the State Department. We were doing a lot of what's called promissory notes. Gene, pull the mic from my hand when it gets too long. Promissory notes, we just got a notice from the state of Michigan. They're going to now stop allowing them as of July 1st. And a promissory note meant, let's say I loan my son $10,000 and I go to a nursing home. Now Medicaid says, oh, you gave away $10,000. That's divestment of assets. So then the fix would be have son do a promissory note, promise payback, and start making payments. Now, July 1st, Medicaid says you can't do that anymore. Why? Who knows? They're bureaucrats. So anyways, don't go close there. Yeah, maybe one little follow-up? Because we are kind of short on time. Go ahead, just short.
So I should make an appointment with you so my wife is protected that way.
Well, yeah. See, Gene I was addressing it from the immediate need perspective. If you want to go into the planning perspective, yeah, then that puts a different spin on it, because then basically what we do in the planning perspective in the Medicaid field, you want flexibility. Just like the fullback with the ball, you want to go backwards, forwards, sideways, frontwards, throw it if necessary. You want to have the flexibility to do anything. That's the best I can say. You kind of have flexibility. So yes, it's good to have a plan. As Gene has been talking about, get your plan in place and do a good job.
So you can see, thank goodness for experts like Jim, right? I think we all love Jim, and he's been doing this a long time. Thank you, Jim. Applause is appropriate. I'll get back to you. Just one follow-up. The one thing you can do for sure is bake into your legal documents the authority to do the planning available. As Jim said, we don't know. We know what it is today. It may change for sure in the summer. Oftentimes stale documents, so powers of attorney and other documents that are 5, 10, or more years old, do not have Medicaid planning powers right in them. And it's like many things, if you need to do something, you better have the authority to do it. It may be too late to go get a new power of attorney. So the one thing people can always do if they're concerned about that potential for nursing home or cost of care is have your attorney put as much juice, Medicaid planning juice, as they can get into your document right now. Because sometimes it's a wait and see. We hope it never happens, but we want the power if it's available.
About the 401k.
Sure.
Okay. Can I comment further, then I'll get your questions, sir. Okay, one more point about the 401k. You need to speak with a professional to make sure that all of your assets are reviewed. Bankruptcy check here. The beauty of a 401k is that is an individual retirement account protected under Michigan law from creditors, protected under federal law from creditors. So if you have an issue with creditors, seen or unseen, known or unknown, you never know when you're going to get sued, quite frankly. Your money is safer there. I also caution you about putting that money into a trust. You can have a trust as a beneficiary, but some people say, oh, I'm just going to lock it up in this irrevocable trust. That's a taxable event. That trust will view that transfer. If you've got $1 million, that trust received $1 million of income that year. And the trust tax rate, I believe, is 34% versus the new lower ones. It keeps changing. I have to check, and it depends on the level of income. It levels. But yeah, be careful. Don't do that. Is not a DIY. That's speak with an investment and a legal professional. Sir, you had a question. I'm sorry.
If you go under the nursing home, do you have to go under Medicaid or do you go under Medicare?
Medicare doesn't. You get the 20 days, right? Yeah.
So short answer would be, if you go into a nursing home, the question was, do you get Medicaid or Medicare? And it can be both. So Medicare is a short-term, get you back on your feet plan. So Medicare will handle up to 100 days maximum during a period for rehab. So when people break a hip, as Jim said, he was talking about Medicare earlier, when someone breaks a hip, they go in the hospital, they're discharged to a nursing home. Medicare generally is the one that kicks in, supplemented by the person's other insurance if they have it, for up to a maximum of 100 days. After day 20, or starting at day 20, there is a copay that kicks in, but it's still cheaper than paying the full amount. Medicaid is and by the way, be really careful if you're in the hospital and you think you're going to need to go to a nursing home for rehab, that you watch out for this admission versus observation status. Family recently got burned. Mom was in the hospital for 3 or 4 days, but she was never admitted. She was only observed. And they went to a nursing home thinking Medicare was paying for it, and then they got the $12,000 bill. And realized, because you have to be admitted to the hospital to get the Medicare coverage for rehab. So you got to watch that carefully. Longer term, Medicaid kicks in, assuming the person qualifies, level of need, financially, all of those things. So Medicaid is usually the one we think of somebody staying in there for months and years. We'll cover. Short-term rehab is going to be Medicare, okay? And we're going to really, one related question, is that?
Well, I don't think you've addressed it yet. If I'm concerned about becoming incapacitated and ending up in a hospital where I don't want to be, I don't want to have tubes, I don't want to have anything heroic, can I go and get one of their advanced directives? Will that solve everything?
So the question is, if an individual is concerned about being in the hospital, being on life support, essentially, and they don't want to be hooked up and kept on tubes and pumped full of juice, I like the word juice today, kept alive, do they need or can they use an advanced directive to address that? And the answer is yes. So, and Jim may have referred to this earlier, not specifically maybe, was the medical power of attorney can include instructions about end-of-life treatment. And you need to be really specific about that in Michigan. It needs to be clear and convincing what your opinion is about life support, assuming you cannot give that consent or make that decision yourself. So it should be part of your plan. You often see these from other states called living wills. Michigan does not have living wills. That's a term from other states. But Michigan uses a patient advocate designation. And you can include your wishes there. Talk to your planner about that to be as specific or general as you wish. Some people want to be kept alive till every penny's spent. Other people are like, look, dude, I've had ladies in my office, usually it's the much older ladies, guys tend to hang on with both hands. I've had ladies in my office say, look, I don't even want them to try, if I don't want a resuscitate order, so I want a DNR, I don't want to be on a ventilator, I'm happy, I've lived a good life, let me go in peace, sort of thing. But you need to have that expressly in there, especially if your kids disagree. I don't do as much probate work as Linda, but one of my nastiest cases were 4 sisters. Mom was in a nursing home, late 90s. The doctor's begging them to take off the code. In other words, put her on do not resuscitate status. 3 of the sisters were like, absolutely. One sister said, no, it's not Mom's time. She needs to stay with us as long as possible. We wound up in court 2 or 3 times she had no instructions written down. We didn't have anybody who was specifically in charge. And remember, all 4 of the kids have equal voice. And so the judge wasn't listening to us. In fact, he listened to the one sister who thought Mom should stay alive. And so it took 2 hearings to get it reversed. Point is, have it in writing, be very specific, absolutely correct. So I'm going to at the end, I'm going to defer questions now. And I may be too far from the mic, but I'm going to jump real quickly through a couple of hoops. The information is here. You can see us afterwards. There'll be time for questions. 3 things. Number 6, 7, and 8 are basically the same idea. Everything is left to one child because they'll do the right thing. Or, one child's really struggling, and we really don't like their spouse. Okay, it's the evil daughter-in-law or the evil son-in-law, so we're not going to give them as much. Or they have a problem. Or we just, again, choose the wrong person to be in charge just because they happen to be oldest or the bully. Any of those create a problem. Leaving everything to one child thinking they're going to do it right is a mistake. First of all, think of what you're doing to that child, the burden you're putting on them. And think of the target you're putting on them from their siblings. Well, you know, it just creates all kinds of hard feelings. It sends the wrong message. Sometimes it causes problems for them. If there's a big IRA and they have to cash it in and then share it with their siblings, guess who's paying the tax on the distributions? It's the one child, and nobody else is paying, and I don't know if they'll be able to force them to pay. And there's the problem what if that child has passed away or passes away and that money isn't protected for the others? It just fades into that one child's own estate, and it gets lost, you know, down the road there. Good luck trying to get money back that mom left to you for your brothers and sisters, right? Once it's gone. Unequal distributions, just automatic fight. To me, yes, you can do it. If you want to disinherit a child, you can do that. You don't have to leave children anything. That's got some leverage. But just believe us when we say that's a recipe for a fight.
Yeah.
You might have some thoughts on that.
On the fight?
Well, okay, we'll come back to it.
Yeah.
Also, when people like Linda said, one son didn't send I had a lady that would change her will every Christmas, after every Christmas. Guess why? It depended on who sent her cards. Johnny didn't send me a card this year, he's out. No joke. I did it 10 times. I finally told her I'm not doing it anymore. This is ridiculous. You know, I was much younger then. I should have stopped her the second time. But I said, hey, she was paying me, so we're just changing that will every year. But what happened if she really meant for everybody to be included and she never got back to it? It can be a real problem.
Don't use your estate plan for discipline. Don't do that.
Right.
Yell at them. Call them up and yell at them. Don't change your estate plan.
And I'm going to let Linda address the last 2 points because we want to make sure we're not exhausting you.
Oh, forcing.
2 issues that can be a problem is forcing the kids to work together. Oh, you know, I love all my kids equally. I have a hard time picking between them. Let's just put them all in charge. Or the blended family. Lots of good stories, lots of potential problems there. I'm going to let Linda take
Lots
those.
of litigation, absolutely. One of my specialties is working with second marriages, third marriages, and making sure that children from a prior marriage are not disinherited. And usually children from a first marriage are accidentally disinherited. So you've got husband and wife love each other, dad dies, leaves everything to his wife. She gets remarried. They love each other. And she promises, oh, I'm going to take care of the kids. And she really intends to take care of the kids. Well, she dies, everything goes to a new spouse who never knew these other kids, never knew the first spouse. Well, of course, his will just totally disinherits. Or maybe he intended to, but he gets remarried. It happens. You saw this in the Johnson & Johnson big, you know, dad developed dementia, married this beautiful person 40 years younger than him. Totally, everything went to her because she said, don't worry, honey, I'll do the right thing. I'll take care of the kids. Multi-million-dollar litigation. They basically said he was subjected to undue influence and fraud. So that is very, very, very dangerous. Kids and disagreements. Keep in mind, children act differently in your presence than they do outside of your presence. Also keep in mind that money changes people. So I've seen situations where once dad, the patriarch is gone, you get all kinds of infighting. Usually fighting over who's in control of mom and her money. Now how do you become a guardian? Well, you usually have to show that that person is incapacitated. Well, half the time mom isn't incapacitated, she's just being bullied. So I've had to go to court to say, I've got a trial coming up next week. We're working on a PPO. We've got a son who's insisting that the people in this assisted living facility is not properly caring for mom. He's kind of a wackadoo. He's forcing her to drink Ensure to the point where she's gagging. Eventually the nurses have caught on and they've thrown him out of the facility. Well, we have him on videotape. He broke in. He pulled open the door. So the police were called properly and a trespass action was brought against this individual. The cops dropped it. We just found out last week. Well, he wanted a jury trial. He demanded discovery. We just dropped it. It's too much work. Well, thanks, guys. Thanks for looking out for the taxpayers. So next step is going to the judge to get a PPO. And once there's a PPO, if it's granted, we'll have to do that. But it's a terrible situation. Mom's competent. She is. She's just being bullied, and she's scared to death of this other son. So, also had a case, keep this in mind. Dad chose the right daughter. Eight kids. Chose the oldest girl. In this case, she was the most responsible one. But upon his death, they started fighting with each other. This family had 2 special needs children. One of the daughters sold their beds out from under them and gambled it away. And we had to keep chasing these people around. This trustee, it was a trust. The idea was to circumvent probate, right? She came to my office with a giant box, and she said, I hereby knight you. You are now the trustee. I'm appointing you. So I had to go chase these people and get all that money back. I had to build the estate for that, or the trust for that, unfortunately. But we did get all the money back. So keep in mind, yeah, Mom, I'll do the right thing. Mom's gone. People change. Just really listen to your children. Really pay attention to that dynamic. Is one child being bullied? Maybe there's one who's caring for you and who will do the right thing. But are they subjected to bullying? Are they a little wishy-washy? Do they get along too well with everybody where they won't advocate for you properly? Really take an honest assessment of your children. It's not easy. It really put some effort into it.
We mentioned we didn't really hit on blended families. That's a very complex area. Just understand that there needs to be special planning in those scenarios because there's usually kids on one side, kids on the other side, and they're each not wanting their parent to pay for the other spouse's long-term care. So it just creates all kinds of issues. People inadvertently get disinherited. We talked about that. I love the forgotten beneficiaries. Had a 60, 70-year-old man in my office this week. His 98-year-old father is still the beneficiary of his life insurance. His wife goes, what? Because I happened to catch it in some documents that was in front of me, and I said, who's this? Is this your son? No, that's my father. Like, well, isn't your dad, is he still living? Yeah, he's 98. And his wife is going bananas, like, I thought you changed that to me. The forgotten beneficiary designations are sometimes a problem. And that becomes an issue when people get remarried. So in blended families, if they haven't ever changed the beneficiaries, sometimes the new spouse who really they want to take care of gets disinherited, and the ex-spouse winds up getting everything. So you got to be careful with that. All of this, we've talked about, wow, this can be fixed in probate. A lot of times people want to stay out of probate. Keep in mind why you want to stay out of probate if possible. So good planning, the idea is to let somebody step in right away with no challenges, with no objections, and take over and do what needs to be done. That's the way it's supposed to work. As Linda has shown you, if that doesn't happen, sometimes and usually court is required to fix it, okay? But the reason you want to try to stay out of probate court is, number one, you're relying on a third party who's maybe not paying attention really to make the decision. It's judges' personalities. My favorite is you go to court, they'll call the case. So we step up to the podium, Your Honor, we're here to represent so-and-so. The judge is talking to his clerk. We're advocating our case. The judge isn't even listening. And we get maybe 5 minutes, 10 minutes at that particular setting. So probate is not the ideal situation where they're really going to listen to what's going on. It's a very slow process. What was that number you used? 12 years in a case? And it's not it's not about justice. People go into court thinking, I'm absolutely right. As soon as the judge hears my story, bingo, I win. It never happens. The probate and the court process is not about justice, it's about resolution. There's going to be a resolution, but it may not be just, or it may not be entirely fair. So there are problems with probate. And then just to remind you of where we started, you want to make sure you got the right person. See if you can repeat it with me. You want the right person with the right power at the right time. If you can have those things in order, you'll save a lot of grief for your family. Make sure you include long-term care planning, Medicaid planning in your legal documents, especially if it's for somebody later in life. And make sure you review your documents frequently, at least every 5 years. That begins to even shrink as people get older because life events start coming at us faster. That's all we have for our part of this. There's going to be time for questions coming up. Jim will be back up here to hit things. If you need to go, we understand. You've been very patient. We hope this is very informative. There's materials in the packets. Read through it. If you have questions, you have at least 3 attorneys that you can talk to if you need information. Thank you again.
Okay. What says you do not have to leave anybody anything? What if you leave, and we're talking about blended families too, because that gets into the word of the stepchildren. You don't have to leave anything to anyone, but do you have to designate in your paperwork those names?
That you're not leaving something to.
Right, and do you also, do you have to leave any monetary value to any of those people?
So essentially the question is, how do you disinherit somebody? So do you have to specifically list them in the document? Part of the question was, what is the authority to say you don't have to leave? You can choose who you leave things to and who you cut out. There were several parts to that question, but essentially it's, can you disinherit whomever you wish, and how do you do it, correct? So first of all, there's this, it's a part of ownership, so it's almost a constitutional right that a person is entitled to leave their property to whomever they wish. It was theirs, they could do with it what they want. There is a natural expectation that a person is going to take care of family. So when family is disinherited, frequently it's like, well, that's not natural, right? So there must have been a problem. If all the money goes to the caregiver who was taking care of them for the last 2 years of their life, and the kids are disinherited, the red flags start going up. Now, the person can do that. The person who passed away could have left it all to the caregiver on purpose. The best way to do that is to, number one, meet with an attorney, make sure that you've gotten rid of any indicia of undue influence, of incapacity. So we'll frequently get doctor's letters for older people and say, doctor, tell us this person is of sound mind, able to make good decisions, because they want to disinherit one of their children. We want to back that up. And then in the document, we want to say, I'm not leaving anything to this child on purpose. We may or may not give the reason for that, in case sometimes there's a problem with that if the reasons change later. You don't have to say you're disinheriting them, but it usually is a good idea. As far as leaving them something monetary, that was an old sort of common law thing where I leave them $1. You don't have to do that anymore. You can just say, I'm not leaving this person anything. One thing to keep in mind, if you're inclined to disinherit your spouse, you can't do that with a will. In Michigan, a spouse can always toss out the will that disinherited them. There's other ways to do it. You might want to not, if you're here with your spouse, you probably want to see his private. It's kind of a joke. So there is a right way to do it, is the short answer. When it's just done informally and there's not really a structure, it's a way for somebody like Linda, a good probate attorney, to come in and challenge it and say, oh, they just forgot. There is this something called a pretermitted heir theory. So if you have 4 children and you only name 3, there's a legal theory that says, oh, that one you forgot, you just forgot, they're back in. So there's a lot of legal theories out there that can play into this.
One more thing I wanted to ask you. As if you make out a distribution list designating where you want your money to go to, or your assets, whatever, is it a good idea not to let that distribution list be seen by until after you die?
So should you show your cards before they're played? So if you have a list, you have a specific way you want things distributed, is it a good idea to show it before you pass, let everybody know, or should it be a surprise at the end? And from my perspective, it always depends. It depends on the family. Some people just don't, it's going to be so dramatic and such a shock, they don't want to just blow up the family, you know, until it's absolutely necessary, and they're gone and they're not there to see it. In some families, it's actually a good idea, especially sometimes where there's like a disabled child. So we've had adult children, say with Down syndrome, sometimes we run into that. So everybody in the family knew, you know, either we were going to put it in a special trust for them or they were getting less because they were on Medicaid and so more was, sometimes it is a family planning, but it varies by family, and I'm interested to get your thoughts on it.
Okay. Be careful with your perceptions. I've had more than one client come and this family fights. Oh, well, Judy wanted the jewelry. She wanted my wedding ring. And then it comes up to the time of distribution. Judy said, I said it was pretty. I never said I wanted that wedding ring. But meanwhile, there's all these fights going on along it. I had another woman who was so afraid of drafting a trust because she thought, if I have a trust, if I do estate planning, that means I'm going to die, right? No. Her trust ended up being 125 pages long. She was able to put pictures of every item, and she had the beneficiary emblazoned on the bottom, and she had more fun doing that, but she did get input from loved ones. Do you want this grandfather clock? It's ugly. No. Okay. Susie, do you want this? So now this trust, it was kind of built by a consensus, so there won't be those fights after her. So it depends on your family dynamics.
That's a good point. But I have a personal example of that. My father had an antique Gibson guitar. Both my brother and I play guitar. I just looked at my dad one day and I was like, Dad, you got to tell us who gets the Gibson. It was my brother, unfortunately. I guess because I asked the question, it went to my brother. But it was actually helped. You know, it was fine. But that was an instance where it really helped both of us to hear this is who gets this one item that can't be divided. Okay, more?
You
got questions? Go ahead.
Okay. I have a list of 4 brilliant questions asked by an audience member here. The first question is, do Michigan hospitals require a legal form to allow more than just a patient advocate to receive medical information? Yeah, you need more than a patient advocate. A patient advocate is basically the pull the plug. If you want a loved one to be able to get your hospital records, billing information, you need a HIPAA authorization. That's that Protective and Privacy Act. So our forms have that built in. So our patient advocate forms, we call them medical powers of attorney. So you can help your loved one now, you can make the decision when they're incapacitated, and you can have access. Because you got to pay the bills. You know, you can't, if you don't have access to their protected information, you're not going to be able to pay the bills. Second question. Do Michigan home deeds need to say rights of survivorship if the spouse dies? Excellent question. If a house is jointly owned and the joint owners are married, Michigan law assumes that it's joint tenants with right of survivorship. Not true if husband puts his girlfriend on the house, and I'm litigating that right now. Oh no, he intended that to be rights of survivorship. No, Michigan law, it says tenancy in common. I'm going to explain what that means. Rights of survivorship, one joint owner dies, that interest is vaporized and everything goes to the surviving owner. Joint tenants, a tenancy in common, I'm a joint tenant in common, I die, my half share goes to my family, and the survivor's half share goes to that family. You've got these multi-million-dollar mansions, you want both sides of the family to share, a tenancy in common would be appropriate. But with married people, and if you want tenancy in common, you have to so state, otherwise Michigan law will assume rights of survivorship. That's important. That can lead to disinheritance. Go ahead.
So how do you do it? You just have
It'll be in the deed itself.
okay, the deed doesn't say that, so I have to go to you and get a form?
Yeah, we may have to redo the deed. What she said was, my deed is silent. It just says, my husband and I own. Michigan law, assumes joint tenancy with right of survivorship, so if husband dies, the wife gets everything 100%. Might be a good idea to take a peek at that, just to make sure. Why not put joint tenants with right of survivorship? Actually, your deed probably says tenancy by the entireties, and that's Michigan law. Very few states, Michigan's one of them, have a designation, stepping on the cord, called tenancy a tenancy by the entireties. It provides married couples with additional protections from creditors. So you want tenancy by the entireties if you're married. So I'll take a peek at that deed for you. Be happy to. Question 3, do you have a
I was just going to say on the, real quick. Just to understand, these are sort of general responses. Deeds really are, while they're easy to prepare and they look very simple, they're just on one page, each word matters.
Yeah.
And each of these clauses has an interpretation. For instance, if it says husband and wife, that's automatically a tenancy by the entireties. If it's not a husband and wife and it just has 2 names, that's interpreted a certain way as tenants in common. There is a difference between my brother and I owning a house jointly as joint tenants, as opposed to my brother and I owning it as joint tenants with right of survivorship. Those are, even though they contain some of the same words, they have completely different legal implications. Really, people should not be doing their own deeds. These are not discovered to be a problem until down the road, sometimes years later, especially if the deed's not recorded. But even then, it's when the house is eventually, they attempt to sell it, they realize a problem happened back up here, they used the wrong words, and we've created estates that we have to go back and open up. And there's times, right now I'm opening the estate of a lady who died in 1990 to deal with a deed that was done improperly. So many years later, and the witnesses are deceased, I mean, it's a problem. So be really careful with deeds.
And the 4th really good question on this list here, what is a ladybird deed? Well, the old way of thinking that this was created under Lady Bird Johnson, that she did it, I'm hearing now that that's an old wives' tale. A ladybird deed is an enhanced life estate deed, and it operates kind of like a beneficiary or paid on death designation for a brokerage account or a bank account. Basically, with a ladybird deed or enhanced life estate deed, you, the owner of the home, retain a life estate with all the incidents of ownership. You can lease, you can sell, you can remortgage, you can refinance your home, you can sell your home. And that deed itself will say, if at the time of my death I've done none of these things, I still own the home, then it goes to X, Y, and Z, my 3 children, my boyfriend, or whomever. And there's some Medicaid possibilities with that, and I'll let Jean discuss that. But that's a good way to avoid probate. If you don't have a trust and you want to make sure your house avoids probate, that's a good recommendation to do that. There is, should care be in joint? I didn't understand that question.
Cars, I think.
Should cars be joint? I don't.
Should your cars be
Joint only.
rentals or by individual?
Upon death, if they're jointly owned, it makes it easier just to change that title. If your husband is a really bad driver and you think he might get sued, or he tends to drink and drive a lot, don't get on there, because then you'll be sued jointly. You're a joint owner of that car.
And one thought on that. So again, different attorneys have different approaches to things. I generally say the primary driver of the car should be the person on that vehicle. Because if there's an accident, I'm driving, the car's in my name, I'm the one that gets sued. I can't sue my wife, she's not driving, she's not on the car, she's not a co-owner. If we're both on the car, they can come after the owners of the vehicle as well as the driver of the vehicle. So there's sort of this, it's a kind of a type of creditor protection to have one person on one and whoever drives the car the most. The other thing is you can use an affidavit procedure at Secretary of State. The spouse as the next of kin can get that car. It's supposed to apply if there's no probate going on for the first spouse to die, and if the vehicle's under $60,000, or all the vehicles are under $60,000. So there are ways to do this without having both people on the car. Any other thoughts, Jim?
Well, I would just say that, I try to counsel my clients, don't be concerned about lawsuits, because you can never make yourself lawsuit-proof. Rather, the better answer is have sufficient insurance. If you're going to have somebody working in your house, don't have a $100,000 policy, have like a, $500,000, have adequate insurance as part of the answer. By the way, I wanted to raise one thing. I'm jumping out of sequence here. In the book here, and I'm doing this as much for the cable folks, I have to give a caution. I should have done this earlier. Don't pay for help in the home unless you see an accountant, and if you're concerned about long-term care, see an elder law attorney. Paying people for help in home, Medicaid considers it divestment, you're giving money away. IRS considers them, taxes are owed. Just understand, if you're going to have somebody help mom or dad in home, the lady in the neighborhood, please see a professional to get your, understand what you're doing tax-wise, see an elder law attorney about what might happen if the nursing home happens in the future, and you just paid somebody $15,000 over the past 2 years, and now Medicaid says, you've given that money away, we're not going to pay benefits. Huge hidden problem. Gene, back to the program.
Quick question that came in. Is it necessary to remove your spouse's name from a deed after the spouse dies? Do you have to specifically remove their name? The short answer is no, but the way that's reflected is the death certificate is recorded with the Register of Deeds. That way it's on public record. Obviously, if the one spouse that passed first, if it's owned properly as husband or wife, it's going to transfer entirely to the survivor. So you don't have to do a new deed. You can file a death certificate. However, that leads to other thoughts, which are now that surviving spouse may want to rethink the plan. So when there was two spouses and one dies, usually things tend to slide across the table to the surviving spouse. Now there's only one spouse. What do we do? It may be appropriate to put that house in the trust or to do something else with it. So you don't have to remove a spouse from a deed with a document, other than just record the death certificate so it's clear to everybody they're not living and the last living spouse owned it entirely. Hopefully that answered that question. All right, did you have a question, ma'am?
Yeah. Where can I read about how to make, in the future, probably qualify for Medicaid, not right now. So how would I
read about that?
myself about that whole thing? Is it
So a fantastic question is, if a person wants to know more about Medicaid, just has, maybe first time thinking about it, just want more information, you have the privilege of being in the presence of somebody who knows more about Medicaid than pretty much anybody else in the state. I recommend you go to Jim Schuster's website, and Jim, it should just be Jim, I'll let you give your website.
Yeah, thank you, Gene. I'll just finish your thought. Just go to jimschuster.com, and a ton of information, and it's not a membership site, it's free, open to anybody, and you'll get a lot of information. Also, I have the publications. I have the Elder Law mini course. If somebody is concerned about nursing home, okay, cable, I'm back. If anybody's concerned about the nursing home, we have a free publication called The Patient Advocate Guide to Patient Advocacy and Good Care in a Nursing Home. Also hospital, we added hospital too. So my office has free publications. Go to the website. And then after you get your questions in order, see me, see Gene, and you'll be in good shape.
Good.
Should we
All right, I think
go for our personal now?
I think we've pretty much exhausted the questions. Again, thank you so much. Thank you to the Friendship Center. Ma'am, we'll catch you after, okay? Unless you think it's something everybody wants to know? Maybe, okay. I'll talk to you after about that. Okay, so thank you, everybody. And again, thank you to the Friendship Center here in Westland. Hopefully you all come back, and I know they have tons of services. Barbara, we appreciate you so much, and thank you for making this available to the public and including us.